Hello again. Welcome to the Insolvency Law and Practice course. We're looking at our round tables again. This time we're going to be looking at Module 6, Creditors Meetings, Voidable Transactions, Preferential Payments and Remuneration, an area I think that there should be some interesting discussion. Joining us today are Jeanette Muller, a Registered Liquidator, Bill Cotter, a Registered Liquidator and Bankruptcy Trustee, and Glenn Shanahan, a Registered Liquidator, all members obviously of the AIIP. So the first question that I'm going to raise with our guests is with respect to preferential payments, and ask them to look behind the legislation and give us a bit of a practical outcome of what are the practical issues in chasing preferential payments. Maybe Jeanette can have a look at that one first.
Sure. Well, from a practical point of view, the first thing a staff member might be asked to do is to have a look through the company's bank accounts and do a data search, essentially looking for round payments of any obvious amounts that occurred in the last 6 months. So we take that list, we have a look at who those payments might have been made to, and that's a starting point. Now, before you get to there, of course, you have to make sure that the company was actually insolvent 6 months prior to the company going into liquidation. So you would have a look at that as well.
Okay. So with respect to that, Jeanette, are we looking at just general expenses or anything that sticks out that's kind of not in the general business? So a payment to a director, for example, or a person who knows a director or a relation to a director?
No, you're looking at general creditor payments and director payments, so you're looking at both. It's usually a bit of a giveaway if they're round numbers, because as we know, most invoices don't exactly equal $20,000. They'd usually be $2,596.37 as an example. So we try to identify things that don't look quite in the ordinary course of business. And so then we would match that up with the company's records in relation to what their payables are and what invoices have actually been paid. And we start to look for correspondence and other matching documents that sort of suggest there was some coercion, if you like, or some urgency to the payments. So
it's a giveaway, for example, if the payment's been made soon after the invoice, if all other invoices are still sitting on the accountant's desk.
Yes, look, there's a bit of that. Correspondence is very useful. We also get a copy of the company's email, of course, and you go through your accounts payable, and there'll be some emails from different creditors. That's also very helpful to sort of say, well, there was a bit of a lot of hounding, if you like, from certain creditors, so squeaky wheels often get oiled. So we tend to look at those creditors and see if they received more than they ought to have received.
Right. Bill, Glenn, any comments on that area?
Certainly one of the things we would do is also just through looking at the correspondence, is try and find correspondence from lawyers or even litigation. So looking at the litigation list, was there proceedings in train, was there a stat demands filed, those types of things, because obviously that's a good indication they might have known the company was insolvent. Any payments that came after that should be pretty recoverable.
And these days emails are really important. So getting the emails that the directors received, whoever's in charge of accounts payables received. So you really focus on that in terms of gathering evidence to support things. You also talk to the director and ask about whether they had repayment plans with anyone who was hounding them. We also, as a routine matter, send off and get the freedom of information material from the ATO as well. So you do a bank of where you're trying to gain evidence to substantially later support any claims you may make.
So the ATO historically, in the past, has been somewhat aggressive in their debt recovery. So does the ATO feature a lot in preferential payment arrangements?
Yes.
Yeah.
You look for things like multiple repayment plans if they've used garnishee orders, and even though a garnishee isn't a preference as such because they've got security, you look at the whole arrangement with the ATO. So the benefit of that is you more readily obtain information as to the history of what happened with that creditor. Then it's more easy to get the information about the ATO than anyone else. You normally have to go through a discovery process, or you might publicly examine people depending on the circumstances to gain evidence.
So if we have evidence of preferential payments, what's the role, coming from my background, what's the role of your lawyers in this scenario?
Well, generally, you're going to need legal assistance as a liquidator to pursue those types of payments. Payment is only voidable on application by the liquidator. So, whilst the liquidator may send out an initial demand, not too many people turn around and say, "Yeah, sure, here's your cheque." It'll normally involve some types of proceedings, or at least threatening proceedings to to get to a settlement.
I think it's important to remember that the onus is on the liquidator to prove that the preferential payment was made, and there's different elements that you would have gone through to have actually established that the transaction was an insolvent transaction and that it's voidable. And then it's up to the creditor who's alleged to have received the preferential payment to file a defence if they want to. And some of the things that might be included in their defence might be that, it was received in good faith and that they weren't aware of the insolvency. And those things are for them to establish.
I think that's a very good point. It has to be a specific payment. The liquidator can't just say, well, every single payment in the 6 months preference and send out demands to everybody. That doesn't seem to be the intent of the Act. You need to prove that the person knowingly received preferential treatment.
Yeah. And there's a whole issue of whether there's a running account balance is appropriate or not in the circumstances.
Okay. All right, so moving on from there, if we go to voidable transactions, who would like to talk to me about voidable transactions? They're always fun.
Well, I guess the starting point is very similar, and as with preferences, it's very key that we get complete books and records, or as close to complete books and records as you can, day one. So you can't do
just stopping you there. Taking consideration, we've got a company that is in financial stress. Overall, what is the efficacy of the books and records you get?
Well, it's very variable, and in the SME space, sometimes in times of distress, the records are neglected, so they're not always up to date. They're not always thoroughly completed or externally vetted by an accountant, but we can only work with what exists. So we get what exists, and that's normally a data file for mine or Xero or whatever the company's using, the emails, physical records, and anything else that might be brought to our attention that's going to be critical. So in the case of voidable transactions, if you're aware of something that happened that was maybe a pivotal kind of moment in the company's recent history, a sale of a major asset or something along those lines, then obviously you'll go searching for specific records about the transaction so that you can thoroughly review it.
So what is a usual voidable transaction that you would see regularly?
Probably the most common is selling assets at an undervalue.
So a move towards a phoenixing, or?
Oh, potentially it could be part of a phoenix, but certainly phoenix would be one example. So possibly at no value, possibly at undervalue, possibly to related parties.
Another common one might be taking some security for a related party. You might like to try to set that transaction aside so that the creditors can have access to the assets that have been inappropriately secured to a related party. That's why we've
got that lovely Section 588 FL sitting in the corporations law. And interestingly, I teach in the area of the personal property securities area, and that's the most litigated part of the Personal Property Securities Act. Funnily enough,
it's very common because people suddenly realise that things are going down the chute, and so they do all these steps to try to better their position.
Sure. Directors historically in the SME scenario are pouring money into the company, not taking security, and they suddenly say, well, this is not looking good. I need to put my hand up and get some security on this.
Yes, that's exactly correct.
Yeah, and unfortunately they could be too late.
Yes.
So what's the process? If you have found a avoidable transaction, what's the process of basically clawing that back or taking action?
Similar preferences, I guess. We'd possibly initially try a request or a demand, perhaps for more information or explanation from the defending party's point of view, or otherwise just an outright request for refunding or repayment of an amount involved. And obviously, again, you don't often get an immediate admittance and payment, so it would then involve engaging some lawyers and making sure all the different elements are properly considered before you commence proceedings, and potential defences are considered.
And clearly that's a risk return curve you've got to think about when you're engaging lawyers, etc., because we can be expensive.
Absolutely.
Yep.
Yeah, okay. All right, well, sorry.
At times there's an element, I guess, you haven't quite touched on there, which is sometimes you might have a valid claims and whatever, but you may not have a lot of money. So you also need to organise someone who will do it on either litigation funding or someone who's willing to run a matter on a speculative basis. And that's often quite a something that's really has to be considered.
Is there a situation where the creditors or some of the creditors would fund that type of action?
It is, but my experience is it doesn't happen very often.
No, I can imagine.
They've already lost money, and then you're asking...
Pouring good money after bad.
Throwing money in. And to get litigation funding in terms, normally the claim's got to be a certain size for a litigation funder to want to be involved.
Yeah.
If you've got a $10 million claim and it looks good, everyone wants to fund it. You've got a $150,000 claim, probably no one wants to fund it because it's too small.
Too small, too risky. All right, well, we'll move on to something close to your hearts. Remuneration. That's always a matter that's currently before courts and the like. So, Jeanette, again, would you like to tell me what the basics are?
With respect to remuneration?
Yeah.
So there's a number of ways that you can get your fees approved, and the most common is to ask the creditors, present them with an account, tell them how that was calculated, and then if you're lucky, everyone will vote in favour and
Everybody's happy.
it's happy. But every now and again, they don't approve them, in which case you'll have to go to court and do an itemised account, do an affidavit, circularise everyone in relation to those fees, everyone being the creditors and ASIC and others.
So is that called the waterfall effect? So if it doesn't get through creditors, it can eventually ends up in court?
It will
or
eventually end up
creditors' meetings?
Yes, in court if they reject. Or in fact, if a committee of inspection is appointed and the committee of inspection rejects those fees as well. So it's a costly exercise for the liquidator or external administrator to have to go to court and get those fees approved. But they're entitled to be paid, and so they will make that application. And usually they get their fees approved. Although there are some cases that give us some guidance on what not to put through in your fee accounts.
Okay. Well, and your experience, gentlemen, is that the case? That basically, if you're reasonable in your fee accounts, you're going to get it through the courts?
Yeah, a lot of it's about, well, it's not only through the courts. I mean, I think firstly a lot of it's to do with communication with creditors, and so they understand what you've done and the difficulties you might have gone through, and some to justify the fees that you've put forward. So I think if you do that and you've got good communication with creditors, it's a lot easier for them to be in a position where they're happy to approve the fees.
Sure.
If you have to go to court, well then, you go to court and it's time consuming and the like, but that's the law.
So in going to court, you're basically, it's a matter of putting your case before the judge. There's not necessarily another litigant in there, is there? There's not necessarily a creditor against you. It's basically kind of a de novo application before the court.
Well, they can be.
They can
object.
Yeah, they can object, but the judge will make his own, form his own view of the material anyway.
All right. Okay, well, that's basically our round table for this module. So we'll see you again next module. Thank you.